Welcome back to the Deep Dive, where we take your source material, stack it high, and build you a shortcut to genuine, informed insight. If you, and I think this applies to most people in modern governance, believe that a functional, stable state needs, absolute legal uniformity, well, today's deep dive is going to fundamentally challenge that perspective.
It really is.
We're looking at a concept that sounds almost paradoxical. The idea that strength can come from intentionally embracing legal complexity.
That's the core premise we're tackling today, and it's a vital one. We're examining how states, some of the most enduring in history actually, managed not only to exist but to flourish for centuries.
And they flourished because they adopted this dual legal identity.
Precisely. Our sources today let us move past just simple descriptions of legal systems and really analyze the mechanism, the operational how by which they successfully built bridges between what seemed like fundamentally different legal structures.
Okay, so let's unpack this monumental task. We have been handed a truly fascinating stack of sources that zeroes in on three distinct yet legally related case studies.
Right. A long-reigning historical empire, a major constitutional compromise in Europe, and a contemporary ideological republic.
So our mission, for you listening, is to dissect the precise mechanisms, analyze what worked, when it worked, and also understand the inherent fragility of these states built on clear, coexisting legal identities.
We aren't just summarizing here.
No, we are grasping the principle of harmonization in really complex legal frameworks.
We're essentially asking, how did these states integrate what appear to be opposed legal sources? I mean, you've got religious versus secular, national versus national, ideological versus democratic. And how do they manage to get stability out of that?
It sounds like a recipe for chaos.
It does, but the sources argue that this complexity, when it was correctly structured, when it was defined and managed, was not a weakness at all. It was actually the primary engine of their endurance.
And those three foundational examples we are diving into are, first, the Ottoman Empire. They established this classic duality between Sharia, the religious law, and the Kanun, which was the state law.
Then we have the Austro-Hungarian dual monarchy of 1867. A totally different context, creating a constitutional and national duality between the laws of Austria and the laws of Hungary.
And third, we bring it to the modern day with Pakistan's 1973 constitution, which attempts to operationalize a simultaneous commitment to both Islamic and democratic provisions.
The common thread here, and this is the core paradox of this entire deep dive, is that the moment of greatest stability for each of these states, it was the moment when that duality was defined with the utmost clarity.
Right. The second it got blurry.
The second the definition blurred, or the institutions governing the dual system began to compete instead of cooperate, the state entered a period of systemic stress. And that, eventually led to failure or a profound constitutional crisis.
So we have to dissect the operational genius of the successful models first to really understand what was lost later on.
Exactly. We have to start with the gold standard.
Let's do that. Let's start at the beginning with the longest-running success story in our source material, the Ottoman Empire.
6 centuries. It's an incredible length of time.
It's astounding. When we analyze the Ottomans, we are talking about an empire that endured for over 600 years, governing a geographically enormous and profoundly diverse population.
You're talking Turks, Arabs, Kurds, Greeks, Armenians, Slavs, Jews, various Christian sects.
All across 3 continents. The sheer duration of that stability is just, well, it's hard to comprehend. How did they possibly manage to govern this huge, diverse landscape without the legal friction just tearing the whole thing apart?
The answer, and the sources are really clear on this, is absolutely rooted in their highly sophisticated, deliberate, dual legal system.
So it wasn't an accident?
Not at all. This was an intentional design choice. They recognized that one unified legal source simply could not manage the vast administrative, commercial, and religious needs of such an empire.
So they established this foundational principle of a dual legal identity.
2 pillars designed to operate together, each one fulfilling a necessary and, crucially, a very well-defined function.
Okay, so let's define those 2 pillars for everyone. Pillar 1 is Sharia. This is something every Muslim state acknowledges as the supreme religious law, derived fundamentally from the Quran and the practices of the Prophet, the Sunnah.
That's the transcendent, unchangeable constant of their legal identity, the moral foundation.
Right. But tell us more about Pillar 2, the Kanun. What was that?
The Kanun was the law of the state. The word literally just means rule or code.
Simple enough.
And, critically, it covered all the areas necessary for efficient statecraft. So we're talking about administrative law, criminal justice procedures, land tenure regulations, and really complex tax codes.
All the nuts and bolts of running an empire.
Exactly. And it was issued directly by the Sultan. The source of the Kanun wasn't religious revelation. It was grounded in something much more pragmatic. It was based on urf, which was custom, public welfare, administrative necessities.
The craft of governing.
The craft of governing and just the immediate socioeconomic needs of a massive dynamic empire that had to, collect taxes, deploy armies, and keep the trade routes secure.
That distinction is so important. Sharia provides the ethical and moral framework, and then the Kanun provides the operational details.
Yes.
So it's not just religious law versus secular law in the way we might think of it today. It's more of a symbiotic relationship.
It is. One provides the principle, and the other provides the predictable, standardized mechanism for implementation.
And that interdependence brings us to the harmonization principle, which you said was the genius that allowed for its longevity.
It really was. The Kanun never claimed to replace Sharia. That's a critical point. Its specific purpose was to fill gaps.
Fill gaps? How so?
It was there to provide the essential administrative depth that Sharia, as a sacred text focused on fundamental morality and personal status, often did not detail.
Okay, that makes sense.
Think of Sharia as the constitution for morality and family life, but for running an imperial treasury, or standardizing the registration of agricultural land across the Balkans and Egypt.
You need something more specific.
You need detailed procedures, assessments, quotas, deadlines. That is what the Kanun provided.
Let's give the listener a specific example of this operational depth. The sources talk a lot about the complexity of their land and tax system.
Oh, absolutely. The Tayyar system is a perfect example. It was absolutely vital to Ottoman finance and military power.
So how did the two legal pillars work together there?
Well, Sharia provides general principles for just property ownership and, fair taxation. But the Kanun standardized the bureaucratic reality.
Okay.
The Kanun defined precisely who held a piece of land, what their obligations were to the state, whether that was military service or tax collection, and what percentage of the yield they owed.
So it made it predictable.
Completely. This administrative standardization, codified through the Kanun, was a masterful stroke of governance. It brought order to all these disparate local customs. It ensured the state had a predictable revenue stream to fund its operations.
And I imagine it also reduced corruption.
Hugely. It reduced the ability of local officials to just levy arbitrary taxes, which in turn increased public trust and the legitimacy of the whole system.
So if Sharia says all Muslims must pay zakat, which is a charity tax.
The Kanun then says, and furthermore, within this province, you will utilize the Timar system, which defines exactly how agricultural land is assessed. And your local collector, the Subasha, must submit his returns by this date using this standardized format or face these specific legal penalties.
Wow. It creates a vast, transparent bureaucracy that's all based on a fundamental religious principle.
Precisely. And the core legal formula that defined this entire arrangement, and you need to highlight this for anyone trying to understand dual identity systems, is this one phrase.
What is it?
Where Sharia is silent, Kanun speaks. Where Sharia speaks, Kanun obeys.
That is a masterpiece of legal clarity.
It is.
It provides a crystal clear, almost mathematical legal hierarchy. It enshrines the supremacy of the divine law, but at the same time, it creates this legitimate, legally defined space for necessary state legislation to adapt to a changing world.
It preempts conflict.
It does, by explicitly defining the jurisdictional boundaries from the outset.
But this predefined hierarchy had to be upheld by the highest authorities. And this leads to a subtle challenge, a really important one for an informed audience like ours.
Which is what?
Who decided whether Sharia was silent or not.
Right.
And who enforced the Kanun obeys part of that clause.
Exactly. I mean, if Kanun is modern statecraft and Sharia is based on ancient texts, wasn't there this inherent political pressure for the Sultan to constantly try and redefine what Sharia is silent on just to expand his own power?
Of course.
So who held the ultimate check?
That check was institutionalized. It was built right into the religious hierarchy, specifically through the office of the Sheikh al-Islam.
The highest religious authority in the capital.
The highest. So while the Sultan issued the Kanun, its ultimate legitimacy came from the Sheikh al-Islam's endorsement, which was often expressed through a fatwa, a formal legal opinion.
So what if a sultan tried to overstep?
If a sultan tried to issue a Kanun decree that clearly contradicted a fundamental principle of Sharia, the Sheikh al-Islam had the moral and institutional authority, and crucially the political influence, to challenge it.
And that would force the sultan to revise the Kanun.
It would. This institutionalized oversight ensured the legal hierarchy was respected. It was the primary safeguard against the Sultan's secular power becoming absolute.
This is where it gets really interesting, because we can connect this whole philosophy to this historical figure who truly operationalized it, Sultan Suleiman I.
Rule from 1520 to 1566.
We know him as Suleiman the Magnificent, the great conqueror, but his nickname in Turkish, Kanuni, the lawgiver, that tells us that his most enduring legacy was actually legal.
He was a legal brilliant. He understood that military conquest is temporary, but predictable, efficient justice is what sustains an empire for centuries.
So what did he do? Did Kanun laws not exist before him?
They existed, but they were localized, fragmented, sometimes contradictory. He undertook a massive codification effort to formalize and harmonize the duality across the entire empire.
What were the specific areas he targeted for this reorganization, and how did these reforms, practically benefit the average person living in the empire?
His reforms were sweeping, and they focused entirely on making the system predictable and transparent. He tackled property law, standardizing how land was registered and transferred using clear Canaan procedures.
Which would give people security of tenure.
Immense security. He standardized taxation across different provinces, a monumental administrative feat, which reduced the complexity of all the regional levies.
He also reformed the justice system, right?
Yes, he reformed criminal justice procedures, set clear punitive measures, which made justice less arbitrary. And perhaps most importantly, he formalized the court procedures. He established clear appeals processes and judicial oversight structures.
So he operationalized the duality through institutional clarity. How would a citizen, a regular person, navigate this system in their daily life?
It was a system of defined tracks. Matters of personal status, so inheritance, marriage, divorce, fundamental moral questions, those were handled by the Qadi, the judge, under Sharia, and these judges were scholars of religious law.
Okay, that's one track.
But matters of public order, taxation disputes, criminal procedure, the enforcement of state regulations, those were primarily regulated by the Kanun, and they were often overseen by state officials or even mixed courts.
And did the two tracks ever cross?
All the time. Critically, the Qadis often incorporated Kanun procedures into their own courts just for administrative efficiency. This shows the integration was really happening at the ground level. It wasn't just a high-level theory.
That symbiotic relationship is key. And the outcomes really speak for themselves. For 600 years, the empire achieved predictable justice, administrative efficiency, a multi-religious legal order.
That's the millet system, which gave different faith communities space to operate under their own laws.
Right. And all of this created public trust in the courts because of that predictability and loyalty to the Sultan, because he was seen as the institutional guarantor of both divine and just state law.
The Ottomans really do provide the gold standard for achieving stability through structured coexistence. And they did it via a clear hierarchy.
One nation, two legal identities.
As long as the governing principles and the jurisdictional boundaries are explicitly defined, respected by the highest authorities like the Sheikh al-Islam, and then operationalized through systems like the Kanun's standardized Timar structure.
This historical precedent is the essential contrast as we now pivot to systems where the authority is less centralized and the duality is defined by, well, something completely different.
Okay, let's pivot now. We're moving from a historical, hierarchical, religiously based duality to two case studies based on constitutional and political duality.
Right. First, we examine the Austrian-Hungarian dual monarchy from 1867 and then the complex structure of modern Pakistan. What's fascinating is how these models, separated by so much time and ideology, still share that fundamental commitment to duality as a political solution.
The Austrian-Hungarian 1867 constitutional settlement, which is known as the Ausgleich, is a brilliant example of political necessity driving the legal structure.
It wasn't a proactive choice then.
Not really. It was a compromise born of weakness. The Habsburg Empire had suffered some major military defeats, which weakened its central control, and at the same time, Hungarian nationalism was growing stronger and stronger.
So the solution wasn't forced unification.
That would have guaranteed collapse. The solution was to formally recognize the separation while retaining a unified crown.
So the Ottomans used hierarchy to define their duality. But the Habsburgs used geography and constitutional separation to solve the same problem. How did that difference in mechanism fundamentally change the stability equation?
It changed where the friction happened. The Ottoman system managed friction by redefining the Kanun, a legal process. The Austro-Hungarian system managed friction through political negotiation.
Okay.
They formalized two distinct, legally sovereign identities within one political state. So Austria, which was called Cisleithania, had its own constitution, its own parliament, and its own civil, commercial, and criminal court systems.
And Hungary.
Hungary, or Transleithania, mirrored this exactly. It had its own constitution, its own independent parliament, and its own separate courts and legal codes.
That sounds like two completely different countries just sharing a border and maybe a stamp on a passport. What were they actually sharing, legally speaking?
According to the settlement, they shared only two things that required mutual legal and political coordination.
Only two?
Just two. The person of the monarch, the Emperor of Austria, was also the King of Hungary and what they called the common affairs.
And what were those?
Primarily foreign policy, the military, and the finance required to fund both of those shared services. Everything else was separate.
Wait, if they had separate parliaments and separate laws, how did they coordinate those common affairs? Who passed the budget for the shared military? This is where the legal harmonization must have been incredibly complicated.
And this is where the structure of duality gets highly technical. But this detail is crucial for understanding the political struggle behind that legal separation.
Lay it on us.
They established a system of delegations. These were not a unified parliament. Instead, each parliament, the one in Vienna and the one in Budapest, selected a committee, a delegation.
So two separate committees.
Two separate committees. And these two delegations would meet, usually alternating between Vienna and Budapest, to negotiate and approve the budgets for the common army and the foreign service.
That sounds like a continuous high-stakes negotiation process. It must have required both sides to constantly harmonize their disparate legal codes, say their own separate taxation laws, just to make sure the shared military had funding.
Precisely. You've hit the nail on the head. If the common army needed a specific allocation, the Austrian delegation had to legally commit Vienna's parliament to raise that money, according to Austrian tax law.
And the Hungarian delegation had to ensure Budapest's parliament did the same under Hungarian law?
Exactly. The system forced harmonization through clear political separation and mutual constitutional recognition. There was no single unified law of the land. There were two parallel systems forced to meet only at the level of the crown and these delegations.
And the result of this incredibly complex arrangement?
The result was 50 years of political coexistence and multinational stability at a time when the rest of Europe was tearing itself apart through nationalist ambition.
So it proves that duality, when it's managed with that kind of constitutionally defined clarity, can be a political life raft.
Absolutely. The Habsburg system showed that separation, counterintuitively, can actually strengthen the union by respecting distinct legal identities. They preserve the essential, non-negotiable legal identity of Hungary while maintaining the geopolitical stability of a large Central European power.
So the stability mechanism was geographical and constitutional separation.
Unlike the Ottoman reliance on hierarchy, a completely different model to achieve a similar end.
Okay, now let's shift focus again. Let's go to a much more contemporary and, I think, ideologically complex duality. Pakistan's 1973 constitution.
This is a fascinating one.
It is, because here the duality is woven into the ideological and judicial fabric of the state itself. It creates this constant constitutional dialogue, or maybe constitutional tension.
I think tension is the right word. The 1973 Constitution attempts to resolve a fundamental tension by structurally embedding two major, often contending, sources of legal authority.
And what makes this model unique?
This model is unique because the legal identities are not separated by geography, like Austria-Hungary, or by function, like the Ottomans. Here, they often claim jurisdiction over the very same subject matter.
Which leads to that institutional tension by design.
By design.
Okay, so let's detail those two components for everyone. The first component is the Islamic provisions.
Right. These provisions establish Pakistan's identity as an Islamic republic. They stipulate that sovereignty belongs to Allah, and that the Quran and Sunnah are the ultimate guiding sources for all lawmaking.
And it's not just a statement of principle, right? It creates institutions.
Crucially, yes. It establishes specific institutions designed to ensure legal conformity. We are talking about the Council of Islamic Ideology, or CII, which is an advisory body that recommends bringing existing and proposed laws into compliance with the Islamic teachings.
And the other one?
The Federal Sharia Court, or FSC. This is a very powerful body, which has the power to review any law and declare it repugnant to Islamic injunctions.
Okay, so that's pillar one. And the second component is the democratic parliamentary provisions.
These are the provisions that govern the mechanics of the modern state. You have an elected bicameral parliament, the guarantee of fundamental rights, the separation of powers, and the principle of judicial review.
And that's vested in the Supreme Court.
Vested in the Supreme Court, which oversees constitutional matters and appeals.
So on one side, you have religious oversight and the federal Sharia court rooted in ideological sources.
Right.
And on the other, you have parliamentary supremacy, constitutional oversight, and the Supreme Court, rooted in modern common law and democratic tradition. This is where the overlap, the critical distinction from the historical models occurs.
And it introduces profound tension.
Mm.
Unlike the Ottomans, where the Kanun explicitly filled gaps after Sharia had spoken, here, both the parliament and the FSC claim authority over the validity of the same piece of legislation.
So the FSC can strike down a law for being un-Islamic.
And the Supreme Court can hear an appeal on that, either on constitutional or procedural grounds, or it can rule on the FSC's jurisdiction itself.
Let's look at a specific real-world area of friction, because this level of detail is necessary for a deep-dive audience. The sources often point to the debate around riba, or interest.
The debate over riba is a perfect illustration of how this duality institutionalizes conflict.
Oh, so.
Well, since the early days of the Republic, there has been a constitutional mandate to eliminate riba from the economy as it's forbidden by Islamic principles.
Okay.
And the sources detail how the federal Sharia court has repeatedly taken up this cause. It's issued landmark rulings that have declared Pakistan's entire interest-based banking and financial system as repugnant to Islam and therefore unconstitutional.
Wow. What happens when the FSC makes a ruling that massive? A ruling that impacts the entire economy?
It immediately creates a constitutional crisis and systemic stress. The parliament is placed under immediate pressure to enact sweeping changes to the financial system, a massive undertaking.
And where does the Supreme Court come in?
Critically, these FSC rulings are often challenged in the Supreme Court's Sharia appellate bench, and that court can delay, uphold, or overturn the FSC's decision, often based on very complex legal or procedural arguments about interpretation or timing.
So you have this judicial back and forth.
Constantly. The Supreme Court checking the FSC checking the Parliament. It demonstrates a constant state of legal evolution, but also continuous systemic stress caused by these overlapping mandates.
And the institutions themselves have different compositions, which I imagine influences their decisions.
Oh, absolutely. The sources note that the judges on the federal Sharia court are often drawn from high courts, but they must also possess deep knowledge of Islamic law.
Whereas the Supreme Court judges?
They're highly respected,
Yep.
but their training is primarily in common law, constitutional law, and parliamentary procedure.
So the duality isn't just in the legal source text. It's in the judicial philosophy and training of the actors themselves.
Exactly. And that makes the negotiation, the harmonization, a daily, highly complex judicial and political effort. It demands far more agility than the rigid hierarchy of the Ottoman model or the rigid separation of the Habsburg system.
Now we arrive at the synthesis. We have to pull these three colossal legal experiments together.
The Ottoman hierarchy, the Austro-Hungarian separation, and the Pakistani constitutional overlap.
The common thread in all of them is this deliberate choice of coexistence over forced unification. But let's really drill down on the comparative mechanisms.
By analyzing the historical mechanisms side by side, we can see really clearly why some were more durable than others.
Okay, let's start with the Ottoman system. You have the dual legal identities, Sharia and Kanun.
Governed by the Qadis on one hand and the Kanun enforcing courts on the other.
The balancing mechanism was the Sultan, but he was checked by the Sheikh al-Islam.
And the result was multi-ethnic stability, driven by a clear legal hierarchy. The key phrase, Kanun adapted to Sharia.
It was institutionally static and supreme.
Right. Now contrast that with the Austria-Hungary system. It juxtaposed Austria's law and Hungary's law, managed by two completely distinct national court systems.
And the balancing mechanism there was the shared monarch and, institutionally, the political negotiations carried out by the delegations.
Which created multinational stability based on defined constitutional boundaries. It was, my law ends at this border, your law begins there.
The friction was political, not usually legal.
Almost always political. And finally, you have Pakistan. It's attempting to balance Islamic and democratic systems using the Supreme Court and the federal Sharia court as the primary actors.
The Constitution is the theoretical balancer.
Theoretical, yes. And it leads to a constant multi-religious constitutional dialogue. The stability mechanism is this complex judicial negotiation.
But the critical difference, the one the sources continually point out, is the structural reality.
Overlapping jurisdictions cause inherent systemic tension.
That overlap is the central lesson for modern dual systems.
I believe it is. In the historical models, the rules of engagement were fixed. Either one law was inherently superior, like with the Ottomans, or the two laws operated in entirely separate geographical spheres, like Austria-Hungary.
But Pakistan's system forces two distinct philosophical sources to compete for validation within the exact same space.
The legislative output of the elected parliament.
Yeah.
Exactly. The judiciary is not just applying law. It is forced to navigate an inherent philosophical conflict on a daily basis.
This leads us directly to the critical lesson from history, the fragility of that balance. Both the Ottomans and Austria-Hungary achieved incredible stability while their internal legal balance held.
But we need to detail what happened when those balances failed.
Yes, because that is the ultimate cautionary tale for any modern dual state.
When the balance was undermined, the foundational stability just eroded. For the Ottomans, the sources point to the 19th century Tanzimat reforms.
What were those?
These reforms introduce wholly new legal codes, often derived from European secular models, like the French Civil Code.
So they didn't fit the Kanun Sharia paradigm.
Not at all. They were essentially a third parallel legal identity dropped into the mix. This created severe dissonance. The state started interfering in traditional Sharia matters, and the legitimacy of the Sultan's secular power grew at the expense of those religious authority checks.
So the erosion of the canon's traditional role.
It destabilized the judiciary and fundamentally broke public trust in the established legal hierarchy that really paved the way for the empire's eventual demise.
And for Austria-Hungary, what happened there? The legal balance was technically stable.
It was, but the political balance broke down. The delegations continued to meet. But the rising tide of nationalism within both Austria and Hungary ultimately meant that citizens prioritized their specific constitutional identity over the integrity of the shared political system.
So the constitutional boundaries stopped being respected.
They stopped being respected in favor of outright political separation. It was fueled by a legal consciousness that viewed the other part of the monarchy as foreign rather than as a necessary partner in duality.
This is the essential takeaway for any state managing complex, diverse legal identities, especially a state like Pakistan.
Yes, the system doesn't fail because the laws are bad. The system fails because the balance is fragile. When the constitutional mechanisms of coexistence are subverted, either by political interference or institutional overreach, the foundational stability of the state is immediately threatened.
So this brings us to the ultimate central finding, the ratio dissidendi of this entire source material. And the sources frame it all around the crucial role of the courts.
Absolutely. The sources crystallize this point beautifully by contrasting the judicial mandate in a dual system versus a unified one.
What's the takeaway?
Dual legal systems thrive only when boundaries are respected, roles are clear, and courts work to harmonize differences, not escalate them.
The moment the judges,
be the Qadis, Supreme Court justices, or constitutional court members, start prioritizing the triumph of their specific legal identity over the integrity of the dual system itself, the structure begins to fail.
that requires a fundamentally different judicial philosophy, doesn't it? In a unified system, a judge's job is, well, simple application of a single code. But in a dual system, what is the core judicial function?
The core function is the maintenance of balance. Think of the Qadi in the Ottoman system. He needed mastery of Sharia, of course, but he also had to incorporate the Kanun's practical procedures for efficiency. He had to be a master of two systems at the same time.
And in the Austro-Hungarian case?
In the Austro-Hungarian case, the constitutional courts had to respect the fundamental, non-negotiable legal sovereignty of the other half. Their job was restraint, not the expansion of their own jurisdiction.
So applying that to Pakistan's context, the judiciary, both the Supreme Court and the Federal Sharia Court, they must operate as the ultimate bridge.
They have to.
If the court meant to uphold Sharia views the court meant to uphold the Constitution as an antagonist rather than a partner in this mandated harmonization project, then the bridge is weakening every single day.
Right. The Constitution intends for them to check and balance the legislative output, each fulfilling a specific mandate. But if they clash over who has the final word on fundamental rights or the validity of core state institutions,
that institutional conflict immediately escalates into a constitutional crisis.
that is the overarching principle. Courts are the indispensable bridge between dual legal identities. A nation survives when that bridge is strong, reinforced by judicial restraint and a commitment to the overall stability of the dual structure,
So their primary job is facilitating coexistence.
which, as the historical models show, is a much harder and more nuanced legal mandate than simply applying a single, unified code. This deep dive truly shows that stability is not uniformity. It is structured coexistence, managed by careful and often politically fraught legal architecture.
So let's quickly recap the incredible depth we've uncovered here. We looked at three monumental legal experiments in structured complexity.
We had the Ottoman Kanun, which layered state law atop Sharia with a clear institutionalized hierarchy guaranteed by the Sheikh al-Islam.
Then the Austro-Hungarian settlement, which separated national laws under a shared crown, coordinated through those political delegations.
And finally, Pakistan's 1973 constitution, which attempts to integrate Islamic and democratic principles with complex, overlapping, and often contentious judicial institutions like the Federal Sharia Court and the Supreme Court.
And the common truth we found is that the success or failure of all three hinged on the precision of their legal architecture.
And crucially, on the integrity and the philosophy of the judicial bodies tasked with maintaining the balance. Stability hinges on clarity, defining the exact boundaries of each legal identity, not demanding they become uniform.
The profound moral lesson here, which I think speaks volumes about governance in the diverse world, is that unity is not sameness.
It's very well put.
A system can absolutely have two identities, Ottoman and Muslim, Austrian and Hungarian, Islamic and democratic. But in the end, if it is to endure, it can ultimately only serve one predictable, standardized justice.
And that leads us to a final provocative thought that you can continue to explore based on this deep dive.
Okay, let's hear it.
If legal systems can be intentionally dual, what are the primary checks a state needs to implement first at the very foundational moment of constitutional design to prevent those overlapping jurisdictions from becoming a constitutional crisis?
So how do you bake the cooperation in from the start?
Exactly. It's not enough to simply create two institutions. The ultimate design challenge is creating the necessary institutional safeguards that force cooperation and mandate mutual respect before the first moment of conflict even arises.
Food for thought, indeed. Thank you for joining us on this deep dive into dual legal identities and the architecture of enduring states. We hope you feel significantly more informed about how the most complex nations maintain their often fragile balance. We'll see you next time.